Hi there, my name is Attorney Megan Freed. I am here with Attorney Misty Simmons and Attorney Brandy Thomas. We are all from Freed Marcroft. We're a Connecticut divorce and family law firm. We're joining you today to talk about restraining orders in Connecticut. We are going to go through the different types of restraining orders and what the process of getting them or defending against them is like. I want to make sure that I mention that due to the current COVID crisis, we've seen a unfortunately predictable and really unfortunate rise in the amount of domestic abuse that's happening in our state. One of the things that we see historically is whenever families are spending a lot of time in close quarters, think summer vacation or school vacation, families where there's an underlying violence issue and other tensions that turn into violence, that tends to be exacerbated by close quarters. And of course, with stay at home, stay safe, self-quarantine orders in place, we're seeing a pretty unprecedented rise in the number of cases. Misty actually mentioned before we got on this call that she was speaking with some court personnel, and they have a ton of this. So we're going to take you through and explain what the process is, what the options are, and make sure that we help you understand what it would look like, either if you're the person who might be seeking a restraining order, or if you're someone who's someone is seeking a restraining order against, so that you know what you can expect and how things work. And also the place we're going to start, the different types of restraining orders that are available in Connecticut and what the differences are between them. Brandy, will you take it away on that?
Sure. The first thing I want to say to everyone who's watching is if you are feeling unsafe, our advice first and foremost is always call 911. That advice does not change in light of the current crisis we're dealing with. That will always be the advice you will hear from every attorney at Freed Marcroft. The first type of order that I want to talk about is a criminal protective order, and this can be something that may appear after you call 911. A criminal protective order is something, it's an order by a judge, and it's issued in the criminal court. So not in the family court and not in the civil court. And those are typically issued after someone has gone to the police and typically someone is arrested. Again, if you call 911, someone may or may not end up arrested, and this order may or may not go into place. But this is the first type that we typically see. And a lot of times parties will have a criminal protective order, and then we'll talk a little bit further about how that works if you also want to get a temporary restraining order in the family court. The other type of order, which is really important to talk about, is a civil protective order. It is slightly different in a couple of ways. The first is that this is done in the civil court. That's not the criminal or family court. And it's typically granted to an applicant who is a victim of either a sexual abuse or sexual assault or stalking. And if you fall into these categories, you wouldn't, this wouldn't be something that would be entered against an immediate family member or household member. In my experience, I've dealt with these civil protective orders in a couple of different contexts. One would be, friends who you don't have an actual romantic relationship with. Neighbors, I've actually seen quite a few disgruntled neighbors who find themselves with civil protective orders, or classmates. Those are a couple of examples. Similar in style to the temporary restraining order, or the T.R.O. as we call it. But again, this is something that would be ordered against someone who is a non-household or family member. This brings us to what we're really going to heavily focus on today, which is the temporary restraining order. This is something that is ordered by the judge in a family court. And you can do this, again, whether you have a criminal protective order or not. Typically, parties will try and get them together, but you don't necessarily need to have one to have the other. Some of the benefits of these restraining order or temporary restraining orders are that they can last a significant amount of time. Some of them may last a couple of weeks while there's some pending orders entered. Others can go up to a year, which can also further be extended at a later date. It can also protect members of your family, which is really, really important as we're all cooped up at home in very tight quarters. So the T.R.O., it'll apply to a couple of different possible groups. So the first would be your spouse or a former spouse. The others would be a parent, a child, or another relative, again, a family member. It could be someone you used to live with, so a roommate, or someone you're currently living with, also a roommate. It could be someone you have a child with, or that you've never lived with or been married to. So many of our potential clients and clients find themselves, this is great with the custody application. If there's an issue with violence in that case, you'd still qualify even though you're not married. We can also look at this as someone you used to date, or you're currently dating. So again, romantic relationship, current or past. And then finally, a caretaker who is providing housing or shelter in his or her home for a person who's over 60 years old and would be considered elderly. So very expansive, which is great. Again, ordered by the family court, we are seeing, as Megan pointed out, a massive uptick in the granting of these applications. And Misty, can you talk a little bit about what that process is like and what our clients and potential clients could expect?
Sure. Thank you, Brandy. So whenever we're consulting with a client with a potential need for a temporary restraining order, or that T.R.O. that you referred to, number one priority is that we're gathering as much information as possible to complete the affidavit that goes along with the application. So in that affidavit, we're looking for information that is going to support a claim of either physical violence or threat of physical violence. And so we spend quite a bit of time with clients just reviewing the history, dates, and specific events that have happened to support that affidavit. And in signing that, we take their oath, acknowledgement, that's part of the process. And when that paperwork is filed, the reason why that affidavit is so important and the significance of that is that a judge is going to review that paperwork and make a ruling ex parte, an emergency motion. Now we're indicating that without being heard by the parties, we're requesting that immediate relief be granted. So it's really important that we've included all of that information to make sure that they have sufficient evidence to really understand and comprehend what the situation is and make a ruling accordingly. So if in fact that is granted, the restraining order goes into effect immediately, and then a hearing date is set within 14 days, at which both parties are able to appear, and at that point have a full hearing before the judge. But the importance of being able to file that initial paperwork is that it does give you immediate relief. And so that is the typical process as it has always been. And then I just want to shift gears to talk a little bit about how that's changed. So in light of the COVID crisis and all of the precautions, the court reduction in staff, and even being closed a few days now to the public, they've made some changes that still make a T.R.O. a possibility for anybody who's not feeling safe and needs to apply. So one of those significant changes is that now parties are able to sign under penalty of perjury. So what that means is that you don't have to have a notary or an attorney take your acknowledgement. But even further than that, you can electronically file that application. And so we have the ability to file with the court either by email or by fax any applications on behalf of our clients without the need to go to court and be able to file that. So there's less contact in court. One, that solves the problem of being in the courthouse, right? So anybody who's concerned about the safety and is practicing social distancing doesn't want to have to go to court unnecessarily to file paperwork. And so we're able to do that, to accept that signature and be able to file it without going. The other great thing about that is when we're working with clients and we can just get that electronic signature the court is now allowing. So clients can review the paperwork and electronically sign it under penalty of perjury and get that back to us. Another reason that might be in somebody's best interest also is that it may be difficult, given the fact that we are home and under close quarters, that it might be difficult for you to have access with the person that you're asking for protection from. So it might not be as easy to be on the computer and to be processing paperwork, but you can contact our office and we're able to file that on behalf of our clients, which makes the signing process and the filing process much, much faster, much more efficient.
Safer.
It's much safer.
It's
and then the clerical process. Yeah, it's really great. And so the clerk will process that and then let us know if that's been granted. And then again, there would still be the one court appearance. At this point, that has not changed. If the TRO gets granted, a hearing gets set within 14 days, and that would be the one time that you'd be required to go to court. And as Brandy had mentioned, at that point, it could be extended for up to a year in the event that upon further evidence and testimony, if that's granted. So it's really a big change for clients that we have the opportunity to do this so efficiently.
Can you also talk a little bit, Misty, about what happens if the TRO is denied on the ex parte basis when the initial papers are filed? What happens in terms of a hearing, and for people who might find that they think that a TRO was inappropriately granted against them, how quickly can they try to get it reversed?
Right. So remember, one thing that I always point out to clients is that it is a fairly narrow document, right? So we're only talking about physical harm or threat of physical harm. And so it is important that that's what is alleged in the TRO affidavit. And so in the event that somebody has that filed against them, we are seeing that from what I'm hearing, they're scheduling them fairly quickly. It must be scheduled within 14 days. And so if you're the respondent and that's been filed against you, you at that point have the opportunity to appear, let the judge hear your side of the story, give your testimony, and at that point request that the restraining order be dropped.
That's right. And so one of the things that the three of us and the rest of our lawyers here at Freed Marcroft will do is what Brandy and Misty were talking about in terms of getting all of the evidence together. That's not just for the affidavit in the instance that we're helping the person seeking the restraining order, but also in advance of that hearing, whether we're trying to advocate for a restraining order to be extended, or whether we're arguing for our client that it's not necessary. So a lot of this is about information gathering, and then of course doing what lawyers do, which is making legal arguments in order to keep everyone safe and secure and get them to the other side of a volatile situation. Misty and Brandy, I want to thank you so much for joining me today. We really appreciate it. Thanks to all of you. We are here, as are all of the members of the legal team at Freed Marcroft, to help you with this or with anything else that you will need. Please feel free to call us at 860-560-8160 or reach out to us electronically via the website. We are here to help. Thank you so much.